Law Talk on 1480 WSAR is brought to you by the law offices of Sabra and Aspen. Now into the studio with your host of Law Talk, attorney Steve Sabra.
Good afternoon. This is attorney Steven Sabra. You're listening to a Law Talk on 1480 WSAR. We do this show every Tuesday from 1 to 2 p.m. So far today, we've talked a lot about the Aaron Hernandez case. So we'll go back to the phones. Good afternoon.
Good afternoon to you. I got two questions for you. One, the first question is, what do you know about the judge on this case? I know that she's been getting a lot of attention lately because the prosecutor and the district attorney wanted her removed. So what are your experiences with the judge in this case? Could you give us a little background on her and if you have any experience being in front of her? And the second part of my question is, I thought it very unusual that the prosecution would make a motion to remove a judge from this case. Can you talk about the possibilities of that happen and if you believe that they have grounds for that?
All right. So the first part of the question deals with the judge in the case, which is Judge Susan Garsh. And she's been a Superior Court judge for a good number of years. I don't know exactly how long, at least 10, maybe longer than that. And I have had cases before her. I had a case involving actually a Fall River municipal employee who was charged with extortion and other violations of the law dealing with the public employee accepting money. Felony. One was a felony, and one was a couple of them were misdemeanors. And it was a trial in the Taunton Superior Court. And she's very intelligent, a serious person, no nonsense person. I think, in my experience, she treated both sides fairly. I think she understands the burden of proof, and what that means is that she holds the party that has the burden of proof to the standard, which is proof beyond a reasonable doubt. You know, she handles sentencing very seriously as well. The person was not sentenced immediately; it was continued for sentencing, and I know that I submitted a sentencing memorandum to her, and the defendant ended up with a term of probation and a fine. I don't remember exactly the amount or how long it was. So the other part of the question...
Yeah, one of the cases of the district attorney getting his motion granted and removing her from the case. Now, would she rule on that, or would it be an independent judge that would rule on that? I mean, how could she rule, on a claim against herself? That's what gets a little tricky to me.
Well, she's already ruled, it seems to me, yesterday. She heard the arguments both sides, and she said she's not going to recuse herself from the case, and she made that's the right decision. If the government wanted to appeal it, they could, but the district attorney said he was not going to do that. Break again. My name is attorney Steven Sabra. You're listening to Law Talk on 1480 WSAR. The Hernandez case again in the news, and there's some issues or some cases that the U.S. Supreme Court has decided to review that I think are of interest.
Hello?
Hello.
My name is Jason. I'm calling out of Fall River.
Okay, Jason, what do you got?
Well, I'm sitting around with a couple of my buddies, right? Mm-hmm. And we're just wondering, in your opinion, is the fame of Hernandez going to, affect the trial in any way, shape, or form? What your guys' opinion is on that?
Well, I think probably it's the way it's going to affect things is that people are going to be more interested in it. Obviously, there's going to be a lot more attention to it every step of the way. So from that standpoint, certainly, and I think people will have a lot of opinions about whatever happens in the case, the trial strategy, the judge, the DA, the defense attorneys, everything from jury selection to opening statements and everything in between. Certainly, when it comes to jury selection, there's going to be questions that the judge is going to ask of potential jurors, whether or not they know of the case, whether or not they formed an opinion about his guilt or innocence,
Right.
Those types of things. And that's going to be, I mean, everything's important in a murder case, obviously, but jury selection is going to be extremely important. And it'll be a little, it'll be interesting, and it's going to show the difference that jury selection, or how jury selection is done in Massachusetts versus how it's done in other parts of the country and other states, because we don't have jury voir dire in the sense that we don't have lawyer voir dire, or we don't have lawyers asking the questions of jurors like you do in other states, even in Rhode Island. In Massachusetts, jurors are questioned in general by the judge. That's one of the important things that a judge does in a trial, is the jury instructions, because if you don't get those right, that can be grounds for appeal. Good afternoon.
Hi, my name is Mike. I'm calling from Chicago. I had a question about the Aaron Hernandez case.
Okay.
With his shootings in other states, I know that will be brought up. Well, should that be brought up in trial? And if they are, what's the lightest punishment that he actually could receive?
Well, that's a really good question, because I'm sure if I was the prosecutor, I'd be interested in trying to get into evidence prior bad acts, so-called, of the defendant. But if I'm the defense attorney, I would want to keep that out, because the only thing I would be interested in, or the argument would be that the jury should only hear facts dealing with this particular case. For example, if a defendant has a criminal record, that doesn't automatically come into evidence, and generally it wouldn't, and it wouldn't come into evidence at all unless the defendant took the stand, and only under certain circumstances. Let's say the prosecution wants to get in some piece of evidence that the defense contests. So the defense would file what's called a motion in limine, meaning that it's a motion to maybe exclude certain evidence that the government is trying to get in, and they want the judge to hear that prior to the trial and not have that evidence attempted to be admitted during the trial, and then the defense objects. The jury may have already heard it, and as far as its admissibility goes, then it wouldn't be unusual for the defense to file a motion in limine, and there would be hearings with regard to that as well. Again, my name is Attorney Steve Sabra. You're listening to Law Talk on 1480 WSAR.